This week has seen yet two more very large YouTube gun channels join many others, including myself, in disavowing USCCA, a self-defense liability insurance provider, and terminate their long-standing relationships with the organization. Serious concerns about USCCA among leaders in the gun and self-defense communities have been raised for years, including by me personally, and this week's disavowals suggest perhaps a tipping point may be approaching for the organization. In today's show, I'd like to share with you both some of the better-known reasons for why so many have grown to doubt USCCA, as well as a personal experience I had with USCCA that convinced me that the organization was utterly lacking in honesty and integrity. I am, of course, attorney Andrew Branca for Law of Self-Defense, and for those of you who stay to the end, I'll share with you how you can get a free copy of our best-selling book, The Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. Now, most of the gun community will be familiar with the organization USCCA, the United States Concealed Carry Organization, as a provider of self-defense liability insurance. You may also be aware that I personally have been extremely critical of USCCA for many years. In fact, I have a dedicated webpage listing various blogs and videos I've created to explain my criticism of USCCA. I've also been quite explicit that I can under no circumstances recommend USCCA services to anyone I care about. This is particularly the case when there are other, better options for the kind of legal services coverage that USCCA purports to provide. One of those in particular is a competitor of theirs that I do quite a lot of partnering with, and that's CCW Safe. Now, in full disclosure, I'm a member of CCW Safe, and I encourage you to learn more about CCW Safe, why I trust them, and save 10% on your own membership there by pointing your browser to lawofselfdefense.com/trust. I'll put that link in the description of today's show as well. I'm not the only prominent member of the gun community who has been and continues to be critical of USCCA. In fact, I was prompted to do this show by a YouTube comment by my good buddy, Mickey Shook, the owner of self-defense training company, Carry Trainer, who posted this. He writes, "I'm seeing all these gun tubers leaving USCCA. I've been telling you all for years about this stuff, the reasons for leaving. Check out the best, CCW Safe. There's a reason I've been working with them." Now, I'll note in passing that Carry Trainer's YouTube channel has over 350,000 subscribers. I'll include a link to that excellent channel in the description, so it's more than triple the size of my own Law of Self-Defense YouTube channel. But there are other channels far larger than either of ours that share our criticism. For many months, at least, the YouTube channel of Heavy Duty Country, with almost 750,000 subscribers, has been brutally and correctly critical of USCCA. I'll include a link to Heavy Duty Country's YouTube channel in the description. I've spoken with Dan personally in the past. He's a really great guy and he does great work, so definitely check out his channel. And then in just the last few days, and as noted in Mickey's comment, at least two more very large gun tube channels, Armed Scholar with over 770,000 subscribers, and Guns and Gadgets with about 730,000 subscribers, both posted new videos announcing the termination of their prior relationship with USCCA and their transition instead to a competitor provider of legal service memberships.
So in this video, unfortunately, I need to talk about something a little bit different. I need to address why I'm no longer affiliating with USCCA, why I left USCCA, why they're no longer a sponsor on the channel.
And here's the intro from this week's Guns and Gadgets video, which I'll also link in the description.
Hey everybody, I'm going to a little bit of a different video than I usually do. You saw the title, you're here for a reason, and I'm going to address the question that many of you have been asking for over a year. And it's why have I left the USCCA?
Now, not surprisingly, every one of these prominent members of the gun community share a common basis for their criticism of USCCA, and that is the notable failure of USCCA to honor its commitment to defend its members against criminal charges in self-defense cases. The two most prominent of those failures have been Kayla Giles and Alan Coley. Kayla Giles was going through a difficult divorce with her estranged and much larger husband when she says he physically attacked her during a child custody swap in 2018 in Louisiana. she fatally shot him in self-defense and called USCCA, with which she was a fully paid-up member. USCCA paid Giles first $50,000 in legal expenses to her attorney, and then abruptly stopped paying, and never again paid another penny, despite being civilly sued by her lawyer in federal court. Ultimately, her chosen lawyer stopped representing her because he was no longer getting paid. Ultimately, Giles would be convicted of murder and sentenced to life plus 30 years. We'll never know, however, if she would still have been convicted had she been able to retain her chosen attorney and wage the kind of legal defense that the money promised, but not delivered, by USCCA would have allowed her to wage. We'd all like to think that how much money you can bring to a legal fight doesn't affect the outcome of your case, but I can assure you that it does. USCCA has never provided a substantive answer to why they abruptly cut off covering Giles' legal expenses, other than to state in response of filings to Giles' lawyer's federal suit that they simply believe they didn't have a legal obligation to pay. Then in 2023, another USCCA member, Alan Coley, was physically threatened by a YouTube prankster in a mall food court in Virginia. Coley shot that prankster in reasonably perceived self-defense, non-fatally. Coley immediately called USCCA, with whom he was a fully paid member. By all appearances, however, USCCA never followed up with Coley's call, never followed up to have his back, as they so frequently promise in their advertisements. Coley ended up with a public defender and zero support from USCCA. Coley was charged with felony malicious aggravated wounding and was facing up to 5 years in prison, as well as a misdemeanor unlawful discharge of a firearm charge, and he sat in jail for months awaiting his trial. He was ultimately acquitted of the wounding felony charge on the grounds of self-defense, and then irrationally convicted by the jury of the unlawful discharge misdemeanor, which should also reasonably have been covered by the self-defense. He would be sentenced to 9 months, which was satisfied by time already served. As with Giles, we'll never know if Coley could have avoided that one irrational conviction if only he'd had the legal resources that USCCA had promised him. When USCCA's failure to provide Coley with any legal assistance, not even bailing him out of jail during the months he awaited trial, when that came to light, USCCA endured months of criticism by folks like me, Heavy Duty Country, and others, with no substantive response. After these months of criticism, USCCA's president, Tim Schmidt, abruptly put out a video statement saying that, it was Coley who had declined USCCA assistance, a claim that seems ridiculous on its face. First of all, they waited months before explaining that. Second of all, nobody would choose to remain in jail for months awaiting trial rather than receive bail assistance. And no public defender in my more than 30 years of practicing law would turn down financial assistance for his client. Nobody knows better than a public defender that a scarcity of resources is a genuine threat to their client receiving due process of law. After the Giles and Coley affairs, and who knows how many other failures that have not come to public light, it's impossible to see how anyone responsible with good intentions could recommend USCCA's self-defense liability insurance. But wait, there's more, as they used to say in the late-night commercials. Beyond the Giles and Coley affairs, there are other reasons why I believe honorable people should avoid any relationship with USCCA, and that's because in my personal and professional experience, they are simply themselves a dishonorable organization. So today I'd like to take the opportunity to share with you just one of my personal experiences that, in my opinion, exposes USCCA as an organization utterly lacking in integrity. First, I need to provide a little context. Law of self-defense, my own law practice, and I personally am perhaps best known for our book, appropriately enough, titled The Law of Self-Defense. In fact, there have been numerous versions of this book over the years. The very first version, a copy of which I'm holding here, I wrote in a mere 2 weeks way back in 1998 when I was on paternity leave following the birth of my first child. Fair warning, this is a tough book to read. It was written by a lawyer, for lawyers. It's largely legalese. We didn't use an editor. If you have trouble falling asleep, this is the book for you. Fortunately, in 2013, I was convinced by friends to do a second edition of the book, And this time I both took more time and made use of an actual editor. And that effort yielded the greatly improved, easy to read, translated all the legalese into plain English, The Law of Self-Defense, 2nd edition. Our archived copies of that book are in storage, but you can find an image of the orange-themed cover on Amazon looking just like this. Importantly, it was in this 2013 2nd edition of The Law of Self-Defense that I first created and presented to the world the legal framework of the 5 elements of self-defense. Essentially, this was the fruit of my observation after years of legal experience and research into use of force law that all American self-defense law could be distilled down to 5 common components or elements. Those are innocence, imminence, proportionality, avoidance, and reasonableness. You can see these 5 elements discussed explicitly in the Kindle version of the table of contents of that 2nd edition of the book. To my knowledge, nobody had previously distilled the complex body of use of force law down to these mere 5 essential elements. And as you might imagine, this distillation was truly innovative in terms of both teaching and understanding self-defense law, as well as in analyzing and arguing self-defense cases. To be clear, I am claiming this distillation of American use of force law down to 5 elements as a creation of my own intellect. And after decades practicing and researching this area of law, I've never seen any indication that anyone had accomplished this or anything like it prior to my 2013 2nd edition of the Law of Self-Defense. Then in 2016, 3 years later, I was approached by USCCA. They were interested in licensing my 2nd edition book for their members. They proposed to put their own cover on the licensed version and to replace the existing foreword with one written by their president, Tim Schmidt, and would pay me a royalty for each licensed book. My response was positive. In fact, given that the 2nd edition was already 3 years old, I offered to update the book to a 3rd edition and license that new 3rd edition to USCCA, including my legal framework of the 5 elements of self-defense. You can see here the cover that USCCA put on their own licensed version of the book. It's not a very good image. It was the best I could find. But to be clear, other than the foreword and the cover, the entire creative content of the licensed version of the Law of Self-Defense is identical to the Law of Self-Defense 3rd edition, including, in particular, the legal framework of the 5 elements of self-defense. The copyright of the USCCA licensed version of this book is held exclusively by me and my law practice. What's important to know about all this is that obviously USCCA would have been familiar with my 5 elements of self-defense law framework from reading the 2nd edition of the book, because that's what led them to reach out to license the book in the first place. And certainly they would be familiar with my 5 elements framework in the 3rd edition version of the book that they licensed, printed by the thousands and provided to their members and the general public. Indeed, in 2016, I presented a full-day in-person class to the entirety of USCCA staff at their headquarters, in which I covered the 5 elements of self-defense legal framework in depth. So USCCA would most certainly know that it was me, Attorney Andrew Branca at Law of Self-Defense, who was the creator of that 5 elements of self-defense framework. With that context, let's talk about a January 12, 2022 video put out by USCCA on their YouTube channel entitled, "When is it really legal to draw your gun?" Here's the thumbnail to that show, and I'll link it in the description as well so you can watch the entire thing. Again, keep in mind that USCCA has now known for years that the 5 elements of self-defense law framework was my intellectual creation. But in this January 2022 USCCA video, Kevin Michalowski, USCCA's Director of Content, and who was personally present when I delivered my full-day in-person class of the 5 elements to USCCA staff in 2016, he introduced a gentleman by the name of Chip Eberhardt. Following his introduction, Chip spends the next several minutes describing, you guessed it, a 5 elements legal framework for understanding use of force law. Now, Chip refers to these as the 5 pillars rather than the 5 elements, and describes them as innocence, imminence, avoidability rather than avoidance, proportionality, and reasonableness. Check it out.
When we're looking at self-defense, there are 5 pillars that need to be met for justified use of force. Those pillars are going to be innocence, imminence, avoidability, proportionality, and reasonableness.
Now, Chip then goes on to explain each of those pillars in his own words. I'll leave you the link in the description for the entirety of the show because I don't want to include too much. I want to avoid this show being made vulnerable to a copyright claim by USCCA. Incidentally, YouTube, should that happen, the less than 16 seconds of the USCCA video I did just use is being used under Section 107 of the Copyright Act of 1976, which allows for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. But to put the Eberhard clip from 2022 in context, here's about a minute-long clip of me being interviewed by a German television news station in Washington, D.C. way back in 2014, fully 8 years prior to the Eberhard video, describing my 5 elements of self-defense law framework, even back then, and which, of course, I have been using continuously both before and ever since.
The law of self-defense in the United States really has 5 conditions you have to meet to have lawfully defended yourself. One is you have to be the innocent person. You can't have been the person who started the fight. 2, the threat you're defending yourself against has to be about to happen right now. It can't be some future threat that someone claims might happen. It can't be something that's happened in the past. That would just be revenge seeking. The amount of force you use to defend yourself has to be proportional to the amount of force you're threatened with. So if someone pushes you, you can't simply shoot them. One is non-deadly force, the other is deadly force. In a number of states, there's a duty to retreat. So before you can use force in self-defense, you have to take advantage of a safe avenue of retreat. And for all of these, your conduct has to be reasonable. Both you have to genuinely believe it was necessary, and a reasonable and prudent person in the same circumstances would have believed it was reasonable.
Now, I don't know Chip Eberhard. Maybe he spontaneously developed his own 5 pillars of self-defense law without benefiting from my own intellectual creation. Or maybe he's aware that the concept was originally created by my mind, and he thought USCCA, which produced the video, was going to credit me at some point. Maybe Chip attempted to credit me himself, and that got cut out in the editing process. I don't know. But it's imaginable to me that Chip Eberhard himself engaged in no theft of my intellectual work product. There may be an explanation consistent with innocence in the case of Chip Eberhard. There can be no similar explanation consistent with innocence in the case of USCCA, however. They produced this video, which nowhere credits me or law of self-defense with this 5-element of self-defense legal framework. They knew, both as an organization and Kevin Michalowski personally, that this framework was my creation. And they nevertheless presented it as if it were their own, or at best, as if it were Chip Eberhard's. Contemptible. But that wasn't enough theft of intellectual work product for USCCA. No. There's more. Since at least 2017, I've been using the tagline, "You have a gun so you're hard to kill, know the law so you're hard to convict." In fact, the 3rd edition of the Law of Self-Defense, the one that was licensed by USCCA, had that very tagline on the back cover. And here's a radio ad, Law of Self-Defense commissioned in February 2017, that uses that tagline.
You have a gun, so you're hard to kill. Know the law, so you're hard to convict.
Certainly, if you listen to any of my video or podcast content produced over the last many years, you've heard me recite that tagline at the end of every show for hundreds and perhaps thousands of episodes. Well, the January 12th, 2022 USCCA show with Chip Eberhard also had a snappy tagline. In fact, it had effectively the identical tagline.
We carry a firearm, so we're hard to kill, but we need knowledge of the law, so we're hard to convict.
I mentioned that it's theoretically possible that Chip Eberhard somehow, on his own initiative, came up independently with his 5 pillars of self-defense law framework that's substantively identical to the law of self-defense 5 elements of self-defense framework, though honestly, I'd want proof to believe it. But am I also supposed to believe that Chip Eberhart independently came up with the same hard to kill, hard to convict tagline that law of self-defense has been using for almost a decade? Color me skeptical. One thing for sure, whatever Chip Eberhart may have known or not known, USCCA absolutely had to know that both the 5 pillars of self-defense law and the hard to kill, hard to convict tagline that they presented in their YouTube video of January 12, 2022 was the intellectual property of me, attorney Andrew Branca, and of law of self-defense, and yet they chose to use it without credit or attribution, leading the audience to reasonably believe it was their own intellectual work product. Again, it's just contemptible. Now, I've not worried about this, really. I've been aware of the USCCA video for more than a year. I never bothered to address any of this until prompted now by the sudden upsurge in gun tubers suddenly this week publicly announcing their disavowal of USCCA. After all, it's our mission at Law of Self-Defense to get these concepts out to the general public, precisely so they'll be both hard to kill and hard to convict. I don't mind others sharing my teachings on use of force law. Go ahead and use our work product to inform and educate others. I'm not going to sue you over it, not even USCCA. I'd like, however, that our intellectual work product at least be credited to us, even with just a passing reference to our website, lawofselfdefense.com. What all of this does tell me, however, is that an organization so lacking in honor and integrity to make uncredited use of the work product as someone with whom they had previously partnered, and so without the excuse of mere ignorance, is not an organization that I would ever work with again, nor that I could ever recommend others work with. Bottom line, USCCA, 0 stars, would not recommend. So, you may be wondering, if not USCCA to provide legal resources in the event you're facing legal jeopardy after being compelled to defend yourself, your family, or your property, then who? Well, I know that Heavy Duty Country, Armed Scholar, and Guns and Gadgets have all announced that they're partnered with attorneys on retainer. That's attorneys Mark Victor and Andrew Marcantel, who provide direct legal representation to their members following a use of force event. I've spoken with Mark and Andrew and consider them smart and capable attorneys, so AOR is definitely worth a look. There is no single plan that's perfect for everybody, however, and my personal choice for legal services coverage is CCW Safe. I'm personally a member of CCW Safe, as is my wife, Emily, and I know Mickey Shook of Carry Trainer is also a CCW Safe member and proponent. If you'd like to learn why I personally place my trust in CCW Safe and save 10% off your own CCW Safe membership, just point your browser to lawofselfdefense.com/trust. And for those of you interested in learning about the 5 elements of self-defense law from the guy who actually created the concept, I do want to share with you how you can get a free copy of our best-selling book, The Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property, and in which we cover these 5 elements in depth. We translate all the legalese into plain English so you can make better informed, more confident, more legally sound, and more decisive decisions in defense of what you value most. And perhaps best of all, most people tell us they can read the entire book in less than an afternoon. Check the book out on Amazon where it's 5-star rated, but don't buy it there. They'll charge you $25 for the book, plus shipping and handling. Order the book from us, and we only ask that you cover the cost of shipping the book to you. The book itself is free. Grab your free copy of The Law of Self-Defense Principles right now at lawofselfdefense.com/freebook. I'll close up by reminding all of you, here's our tagline, that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law so you're hard to convict as well. Until next time, I remain attorney Andrew Branca at lawofselfdefense.com. Stay safe.